Hello and welcome to another episode of Calm the Conflict, the Art of Resolution with myself, Zakia, a commercial litigation solicitor and debt recovery trainer with David.
Thanks so much. So I'm David Goldberg. I am a litigation dispute partner at EMW Law, and I'm also an accredited Lead Mediator and Legal 500 recognised.
Thank you, David. In this episode, we're going to look at managing client expectations around the mediation process. And I'm going to dive straight in, David, and ask you, how can I usefully prepare my clients about the mediation process?
Okay, so there is a huge amount of information already online about what to expect at mediations and how to prepare for mediations. But from my perspective, from a practical perspective, I think it's very useful if you explain to your client what the mediation process is, that it's off the record. I mean, they appreciate, using terms like without prejudice for lay clients may or may not work. Bigger clients will obviously understand it. But just explain to them that the whole purpose of this is to try and get this resolved in a day. We have normally a day to resolve something that has possibly been rumbling on for months and months or years. It's very entrenched. They've got lines, that they're not prepared to shift, and the other side have not got prepared to shift, and you've got very acrimonious correspondence going around. So if the clients actually understand from you in advance that this is a conciliatory process, and although there's no power on my part to force anything, the process works. The stats show that. We've covered this previously. The whole process does work if they are prepared to engage in that process. So manage their expectations. Say, let's think about what we want to do. Let's think outside the box, because this is not a trial. So we haven't got to go one particular road. A trial judge hasn't got to find for you or find for them or find on isolated points. We can perhaps work a way around, there are certain bits that are stronger, certain bits that are weaker, depending on the nature of the claim. If it's a contractual claim, a money claim, a property claim, a landlord and tenant thing, or a dilapidations claim. There are always various arguments that can be raised. So manage expectations in as much as, what are the strengths of our case? What are the weaknesses of our case? Explain how I'm going to approach the day. You've obviously, when you're picking the mediator, another conversation for another day, different mediators.
We've actually done an episode on that.
We have done an episode on that. So, do you want a mediator that is going to be slightly more like me, a bit more aggressive, a bit more, actually, let's get on with it. Or do you think that your client needs someone that is a bit more, subdued, softer, let's play the whole thing out, whatever works. But then, manage that client expectation, because, I will have a conversation with you in advance, so I'll have some idea of where you want to be. And on the day, there is always downtime. Whether it's a face-to-face mediation or we do it over Zoom, I'll come in and I'll talk to the parties, and I will explain at that point in time, what we're doing, how we're going to do it. We'll have an open session if both sides will agree. They don't have to speak to each other, just so I can set out the rules of the day and basically say there are no rules. It's all off the record. What is said stays here, etc., etc. And to say things like the first party to make an offer is actually, it's a positive in a mediation, as opposed to being the first one in litigation blinks, is seen as weak. And just manage that process, and to understand the day is going to be peaks and troughs. Energy levels are good in the morning. They peak at like 10:30, 11 o'clock. They go down. Then that run up to lunch. The after lunch session is always a bit slower, just because people are getting back into the flow. I think the whole purpose of a mediation is, to tell your clients, manage, it's going to be, that's what's going to happen. Yeah. So it's going to happen. Is that helpful?
Yeah, that is helpful. I mean, from my side, yeah. I usually say to them, it's not like going to court. You don't need to be suited and booted. You're not going to be grilled on or cross-examined, as some lawyers say. You're not going to be grilled on your evidence, because we're not looking at the finer detail or the legal arguments. Yep. So don't put that to one side. Yes, we know what your case is in legal terms, but put that to one side. Think practical, think resolution, be open and be flexible.
Absolutely
on the day.
Absolutely.
And relax is what I tell them. I say to them, relax into the process, because we'll have an independent voice, and you're neutral in the process. You'll go party to party. But actually, in terms of my clients, I want them to be as relaxed as possible and go with an open mind, and say to them they can share anything they want, because it stays entirely in that room. That's my approach.
No, yeah, absolutely right. And I've done lots of mediations with the same law firm, for example. So one law firm has done 3 or 4 cases with different people. And while the lawyers have heard this umpteen times. The lay client hasn't, or the client hasn't. So, very early on in the process, I will say, call me by my first name. I will in advance say I'm not going to be in a suit, shirt and tie, because that's not what it's necessary. It's not necessary. Just relax into the day. And the whole process is, my job is to ease make the parties at ease.
Yeah.
I know they're going to be anxious. It's a bit like when you go to trial. Nobody wants to be on a witness box. The judge knows you don't want to be on a witness box.
Absolutely.
I know people have not done this before. I know they're worried about it. I know that there's stresses and other issues that are going on. So my job is to calm the day, calm the conflict. Move the whole thing down a peg. And if I work with you, that's kind of what you're saying you do?
Absolutely, yeah, absolutely. Because it's already a stressful process for my clients. They're already needing.
But a lot less stressful than trial.
Oh, absolutely, absolutely, without a doubt. But because they've so intrinsically
living the problem.
living it, it's difficult for them. So I'm always there. Well, I'm there to hold your hand. I will be there to support you. I'm on your team, but I want you to relax into it. Just be open and also be flexible and listen to what the other side have got to say. Because I think that's the other key thing is don't shut off and just think this is my case, this is my case. Listen to what the other side have got to say through the eyes and the voice of the mediator.
And I think actually just picking up on one of the points you said, for you to say to the client, I've got your back, I'm holding your hand, I'm here. I will say exactly the same thing. I'm not here to hold your hand. I'm here to find a resolution. That's what the lawyers are here for. My job is to politely bang heads together, get this, move this thing forward. And I think people realise that we have a different role, and that again sets the tone for what is going to happen on the day.
And I think that's one of the main reasons why mediation works, because you've got an independent voice in the middle that's not taking any side whatsoever.
I think that's essential. So I will have emphasised in advance. I will have sent you a mediation agreement. You would have explained that to your client before they sign it. You would have had conversations saying this is entirely off the record, everything, etc. And I will do that as part of the opening session. We have a joint open session, and I will explain, everything you say to me stays with me, doesn't go anywhere else. I'm not going to pass stuff on unless you tell me to, etc. So again, it's just calming the situation and allowing you working behind the scenes when we have these sessions, because we'll have sessions, numerous sessions. It's not just going to be a one. And each time I will try and give you some homework on your side. Say, well, what about that point? Can you think of another way to word that point? Or we've discussed previously, there's a surprise. You've got a surprise for me, okay? How are we going to deliver that? Manage it. And if we manage things, it makes it a far more an amicable process, and people don't want to be surprised. Let's not drop a clanger on the other side.
Absolutely. So the key thing for me is telling my clients, stay calm, stay focused, and keep an open mind. And
don't panic. Don't worry. It's a relaxed environment. I'm not a judge.
Yeah, absolutely. And I think that's it. You're not a judge. You're not there to judge either side.
Exactly.
It's crucial to the whole process of making mediation work and work well.
And that's why it does work. Yeah, keeping it informal.
Absolutely. Thank you, David. We'll leave it at that. Thank you very much for tuning in and listening to another episode of Calm the Conflict, The Art of Resolution. And we're going to be back with more. So make sure you like, subscribe and share. Thank you.
Thank you.
Thank you for listening. This podcast was brought to you by Right Here Creative, a video creative agency based in Oxfordshire. Check them out at rightherecreative.co.uk.